Number 203, People versus Brandon Warrington. Judge DiFiore has recused herself from this case, so we're going forward with 6.
Thank you.
Mr. Carasone, welcome.
Thank you. Good afternoon. I am Jason Carasone for the appellant, the Warren County District Attorney's Office. If I could reserve 3 minutes?
Yep.
Thank you. Judge, the issue in this case is, did the lower court properly use its discretion when it determined that Juror 383 should not be discharged for cause? We know the appellate court majority holding was that there was an abuse of discretion. Justice Devine, contrary to that, dissented and felt that there was not.
Counsel,
Yes.
An issue I never have, but you might want to raise the
Sure.
microphone.
Sorry. Thank you. In common law, if there was any bias raised in the past, that was the end of the analysis. Then we went into 376 became the law, and that brought about the expurgatory oath. We're now in a world of 270-20, and in that world, there is no longer a required expurgatory oath. In fact, it's not even listed in that statute. So without the expurgatory oath, sort of the rules have changed. And the idea is that when the trial court is making its analysis, it has to have an opportunity to look at the individual jurors and make a determination if they're in compliance with CPL 270-20. So the first...
But once a juror has articulated a bias, which I don't think you're challenging here, right? The juror articulated a bias. Doesn't the judge have to clarify that even if the juror says, yes, I can be fair, yes, I will listen to your instructions and the evidence, and I can put aside this bias that I've already admitted to? Doesn't the judge have to have the juror say, not exactly those words, but to communicate that that juror is able to overcome the bias?
Yes, I believe that's true. And I believe that happened in this very case.
How did that happen here?
Okay. As this court will recall, this involved a 5-year-old's death. And so the way that the genesis of this is the defense counsel raises it in voir dire and says, look, this is very sad. It's sort of a compound question. This is upsetting. Will it be difficult for anyone? One juror says yes, another raises their hand. Ultimately, the 2 jurors that become the subject of that inquiry are Juror 123 and Juror 383. And before we even get to the court's interaction, defense counsel goes on and says, I'm concerned that this is a case about kids, and you 2 have raised concerns. Or you may be shifting the burden. Can you assure me, even though this is about children, that you'll base your verdict on the evidence? That's defense counsel's inquiry. He gets an affirmative from the panel, panel of 21, I believe, which by itself probably isn't enough, but it isn't to be ignored either. Then the court becomes involved in inquiry, and when you're looking at that inquiry, what you're going to observe is 2 individuals being spoken to. First, Juror 123, and then I believe immediately following, he goes into 383. And that interchange, that discussion that occurs, highlights what the issue is. And the issue is the same for both jurors. There's a death of a child. It's upsetting, and these jurors...
Wouldn't it have been prudent for the judge to say, when the judge finished with Juror 123 and turned to Juror 383, same questions I just asked that juror?
He does say that.
And what is your response to that? But my understanding of the record is the judge actually asked Juror 123 about the bias that the juror mentioned about this being a 5-year-old and an adult. I don't recall that the judge actually said to Juror 383, remember you said, or same questions about the child and the adult. I don't recall that. Am I incorrect, counsel?
Well, what the judge does is he goes through the full inquiry with Juror 123. And I think one of the things I want this court to focus on is when CPL 270-20 was passed, that judicial discretion that trial judges are afforded became even more important because they want to get that assurance, and I want to make sure I say this right. that the state of mind of the juror is likely to, if their state of mind is likely to preclude them from rendering an impartial verdict based on the evidence, then they should let them be discharged for cause. The courts have said that there's not one method. There isn't that talismanic oath.
No, but we have to get into the weeds here, don't we? We have to really get down into the words and say, is it unequivocal? I
Yes.
guess, I think that's where we have to go. And there's a test in Biondi, I believe, that sets out a two-part test. And really, at that point, we have to parse the language against the test and see if this is unequivocal with 383. 123 is only relevant, I think, is because the reference to the similar questions between the two of them.
The reason I suggest to this court that 123 is so important is because, as we know, this is an abuse of discretion standard. And I want to hopefully answer both questions here.
Yeah, you go ahead and answer, Judge. I didn't mean to interrupt you. Go ahead.
No, I like interruptions. 123 and 383 are being spoken, they're together in the room. They're being spoken to together. The judge is there to assess, are they interacting, are they listening? What we know is that the judge gets what might even qualify as an expurgatory oath from 123, but he keeps questioning because it's clear that he can read body language and there's an issue. As you'll recall, he goes through, this is about a child. He directs, this is the issue. And then he gets towards the end of his inquiry and he says, can you be fair and impartial? And the juror says, yes. And the judge says, I'm not trying to drag this out of you. I want to make sure. It's okay if you say no. Are you sure? And I think they say maybe, or I'll try. And ultimately they...
So that shows that the judge was clearly paying attention to 123. The problem that I have is that it just seems like something was overlooked because he said, I'm going to ask you the same questions to 383, but he never did. And that's the problem. He never got any kind of... there's nothing on the record that tells us that that juror made an unequivocal statement that they could put aside the bias that they had indicated and fairly judge the case.
Judge, I would say that, in fact, the judge did not mirror his questions with juror 123 and 383. I agree there. But the subject matter was clear. This is about the child. They've been raising hands on the same issue. He then does go through and he says...
But the questions went in, the following questions went to, will you listen to the evidence and base it on the evidence? But that doesn't go to whether they're going to be able to view the evidence without this bias that they've articulated.
I think when taken in the whole that it does, because the ultimate question and the question that's raised by the statute is, do they have a mind likely to preclude them from rendering? That's what the judge has to decide there. He's there. He can see the head nods. He can see whether people are paying attention. That's all present. They're afforded that discretion for a reason, because as we know, when you're in the room and you're seeing the context and the interchange, it's different than when you look at a bare record on paper.
But everyone agrees that it's a tough case, and it's the candor of these prospective jurors admitting, this is tough. I don't see how I can do it. This involves a child and this adult. I mean, how can we, just looking at a record that, as Judge Stein has already pointed out, this questioning with this particular juror, 383, is about this burden of proof without ensuring that the juror is not going to look through the lens with bias in deciding whether or not the prosecutor has met their burden.
Well, in I think the Johnson holding, this court said that the trial judge has to, in some form, get the assurance. And it's.
But if you don't ask the question, how are you going to get that assurance?
Well, I think the judge did ask the question.
But not to this juror.
To
right?
this juror, didn't ask the identical questions, but did ask the question, if the people, and I'm going to summarize the questioning that he asked to 383. He said, there was a follow the law discussion that goes on later. He goes through that at length with that juror. He also talks about burdens of proof and following the law and the evidence.
Yes, but the problem, it's the same problem, because in deciding whether the people have met their burden of proof, if you have this bias, then it's going to influence that conclusion. And that juror was never asked whether they could do that.
The judge does not.
Let me ask you this. Do you concede that if the judge hadn't asked sort of the bias questions to the prior juror, the juror just before this, and had just started asking these questions, the ones that are on the record to 383, that wouldn't be good enough? Do you concede that?
I don't like conceding. I would say that it wouldn't be ideal if you just took that snippet in isolation and looked at it alone. But I don't think that you have to look in isolation and just say, I'm going to only look at that. We do have the defense counsel, before any of this, goes through his, I'll call it rehabilitation, with these jurors on this issue. He gets a group affirmation. And then we do have the individual inquiries that the judge does. I guess the question is there some, I don't like talismanic, but that's the word that we see all the time. Is there some magic language that needs to be said? Do they have to follow almost a script, the judge, or can they be relied on to look at the total picture of what they've got in making their determination if this person should be discharged for cause?
It doesn't have to be talismanic. I understand your point with that. The question is whether or not the juror has said enough that clarifies that bias will not be the basis by which the juror considers all of the evidence presented and eventually renders their vote when they deliberate.
Well, the ultimate question is, for a trial, is can the juror follow the law and base the verdict on the evidence? And those were the questions.
But no, it's not. I mean, if a juror says, I believe, I have a bias, I believe that anything a police officer says is true.
Right.
Okay? And then you ask the question, well, will you base your verdict on the evidence? Will you follow my instructions? Yes, all of that I will do, absolutely. But there's still this bias. So we know that whatever the police officers who testify, that juror is going to take that as true. So that colors everything. And I think that is the point of having to have some articulation that the juror can overcome that.
What I would say is when you look at the cases that have come before here, what's typically happened is there's been a bias that's been raised and there's been no inquiry. That's a number of the cases. Or there's been a bias that's been raised, and there's an inquiry, and at the end of the inquiry, the response is equivocal. And that's happened time and again. I'll try, I'll do my best. We don't have an equivocation here. We do have a juror who's saying, I will follow the law as you, judge, give it to me. And part of the law and part of the requirement is that you are impartial. And I believe the court discusses impartiality at the beginning of his charges to the jury, and it's been heavily discussed throughout this record as we know, one juror is disqualified, juror 123, because they ultimately, just prior to this, say, I can follow law, I can't do it, and they ultimately equivocate in the end.
Thank you, Mr. Carson. You have your 3 minutes.
Thank you.
Mr. Conley, good afternoon.
Good afternoon, Your Honors. Initially, I'd like to point out that it's not correct to say that Juror 123, the juror who was questioned immediately preceding Juror 383 by Judge Hall, was ever asked specifically whether he, I don't remember if it's a he or she, says he, whether he could put aside his bias. It's true that that juror did ultimately say during that questioning by Judge Hall that he couldn't be fair in the case.
Have you ever had a situation where you ask somebody the exact question and they look at you right in the eye and they say, sure, I can be fair, and you know they're not going to be fair at all?
Sure.
So how do you tell from a cold record exactly what went on, in a situation like this? And shouldn't we be deferring to what I'm going to surmise is a fairly experienced judge who asked these questions, got these answers, and was satisfied?
Well, the law from this court is clear that there is a place for this court to be deferential to trial courts. And that would be if the trial court, or counsel for that matter, it wouldn't matter whether it was counsel or trial court, had obtained from the juror an express statement that he will not be influenced
Well, when you
in
look
his
at what was
deliberations.
asked and what was responded to, as Mr. Carson told, it's conceivable to me that a judge could say, looking at this and seeing, and as he points out, body language, et cetera, that I think this lady can be fair. And I think about that because I can't imagine in any veneer anybody that doesn't have some reservations when there's a claim such as this, a child being killed by an adult. And so most of the people who said, oh, sure, I could be fair, those are the ones I would think sometimes you'd have a little more question with than somebody who very candidly says, this is troubling to me, and then is asked a series of questions that she says, if the evidence says not guilty, I'm voting not guilty. If the evidence says guilty, I'm voting guilty. And I don't know where we step on a judge and say, well, you had to do something more, and I can't think what the something is.
Yes.
I guess that's a question.
Okay. I go back to the history here that Mr. Carasone alluded to briefly. There was a time, I think it was before about 1870, that once a juror expressed a bias of the sort that this juror 383 expressed, that would be it. That juror was out, no more. However, the law became somewhat more liberal, I guess statutorily, through the legislature, saying that, well, we won't necessarily exclude a juror who expresses a bias like that, but before that juror can possibly be allowed to serve, that juror has to at least expressly state that he will not be influenced in his deliberations by the bias that he expressed.
He or she will follow the law, which I think was said here. And before this juror never sat, right? I mean, the argument here is that there was an exhaustion of peremptories.
Yes.
Okay, so this juror was never in the case.
Yes, correct.
I'm
I'm sorry, was there a question?
Well, no, I just want to make that clear because it's not like she sat and then because of her bias, a verdict was rendered. And I understand the whole, thing about, that because he exhausted his peremptories, he therefore, was out of opportunities to challenge someone else. And I realize too that that's difficult. But my point is that in this whole thing, how do we say this judge did not do what at least he was satisfied with, and that this juror, could be fair, and of course the defense has the right to excuse them if they want to.
Because the law from this court is clear that once a juror has expressed a bias of that nature, the juror has to make two expressions, has to explicitly say that he won't be influenced by that bias. I think that he can put that bias
So
aside.
you say this judge should have said, you said before.
Yes.
And therefore, I want you to specifically say that you will not make your decision based upon the fact of the age difference and that an adult is alleged to have injured and killed a child.
Yes, because once a juror has said, this juror came out and said,
The judge did
I
that
can't be
with
fair because of
123.
this, I'm biased in this case because of the age of the
But that's not really
child.
what he said, right? Don't you have to look at kind of what the back and forth was? I mean, he says, could you be fair and impartial? It's a 5-year-old, I can't do it, says that. But then there's further Q&As where the defense counsel is asking him, the burden's for the people to prove beyond a reasonable doubt that I did do it. And defense counsel says, can you agree with that? And 383 says yes. And then counsel inquires, despite the fact that it's a young child, it's emotional, let's face it, this is an emotional thing, you still cannot shift the burden to the defense. The burden is not for me to come and show I didn't do it, the burden is for the people to come. And defense counsel says, do you agree with that? And as the veneer, juror 383 says yes. Counsel then inquired if any of them would have difficulty finding defendant not guilty if the people failed to meet their burden of proof. If the people did not meet their burden of proving each and every element of the crimes beyond a reasonable doubt, would you have a problem finding the defendant not guilty? 383 says, I don't know. And then following that response is when the court inquires, so specifically of that juror. So don't you have to look at that entire back and forth to say what does the judge have to do at that point to satisfy themselves that he has given an unequivocal response to, can you be fair and impartial?
Well, if the court, if you're asking, does this court have to look at the entire record of the voir dire?
Right.
Sure.
It wasn't, I can never do this, it's a 5-year-old, let's go to these questions. There was more in between there. There was other questioning. And then at a certain point, the judge steps in and questions those two jurors. So I think the way it's been going here, we're seeming to suggest that it's a 5-year-old, my God, I can never be fair and impartial, let's go to these questions. But that isn't really the sequence of what happened here. And to get to Judge Piggott's questions, it seems more of, this was a trial judge who's letting this process play out, there are different questions that are asked, and finally at that point where the question is, I don't know, the answer is I don't know to a question that says, if the people don't meet their burden of proving each and every element, beyond a reasonable doubt, would you have a problem finding the defendant not guilty? 383 says, I don't know. The judge then comes in and questions these two jurors. Why don't you look at all of that in terms of what the judge then asked, who's there and who's hearing all of this and watching this, to see, is this answer unequivocal, rather than put in, and you can call it a talisman, or the need for the judge to say, at one point you said it was a 5-year-old and that would bother you, and now can you tell me, even though it's still a 5-year-old, whether you can be fair and impartial? Why won't we look at all of this to see whether those answers indicate he could have put aside whatever he expressed as his reservations and given an unequivocal answer that I could be fair and impartial?
Because even if you look at all of that, it still doesn't amount to a question to that juror, having expressed this bias in this situation, can you put it aside? Can you assure us that it will play no role whatsoever in your deliberations in this case? Now, it's quite possible that the juror could answer all the other questions. Oh, yes, I'll be fair. I'll obey all your instructions. I'll do everything that you say that I'm supposed to do. And yet, when confronted with that question, can you really put that bias aside? The juror might say, as in Blyden, the case involving a racial minority, the juror said, when confronted with that question, the juror said, well, I'll try.
But I don't know, I know the case, I know that part of it, I don't know what happened before, but in this case, you have a defense lawyer asking the panel before this questioning about the young child. After he gives this initial, 383 gives an initial answer of, it's a 5-year-old, I can't do it, the defense lawyer gets up and asks questions and says, it sounds like you're shifting the burden. That's what I'm afraid of. When you have such a young child and it's emotional, let's face it, it's an emotional thing. The burden is not for me to come in and show I didn't do it. The burden is for the people to prove beyond a reasonable doubt that I did do it. And defense counsel then says whether you all, to the veneer, can agree with that. And 383 says yes. So does the judge then have to repeat that later?
I'm sorry, Your Honor. And are you saying, and I don't have that in front of me, are you saying that the whole veneer agreed with that?
But then 383 agrees. But the judge then has to single that juror out later in the individual colloquy. When he's really following up on this later question, it seems to me, if the people did not meet their burden of proving each and every element of the crime beyond a reasonable doubt, would you have a problem finding the defendant not guilty? He says, I don't know. And then the judge steps in. But you've had, some of them are direct questions, some of them are questions to the panel, but 383 is answering them. Why isn't it all of that, that as Judge Pigott says, goes into this trial judge's determination of, is this an unequivocal answer, rather than none of this had happened. He mentions this 5-year-old says, I can never be fair and impartial, and then the judge says to him, there's a 5-year-old here, can you be fair and impartial? And he says yes. That would be okay, but the whole process here, because he doesn't say those magic words at the end, is not.
Well, it's not really magic words, but it's an actual expression of an ability to set aside a previously expressed bias.
Right.
And
the
that
question,
questioning of Juror 123 on that very issue, right?
I'm sorry?
Part of the context of this is that the judge also questioned Juror 123 on that very issue, but didn't do the same thing with
Well,
this
he
juror.
said, he said the same questions to you, and in my world, that I don't repeat them all. It's just, you know, you same questions to you. Do you have any problem with that? And then the answer is no. You know.
No, but the judge never asked Juror 123 whether Juror 123 could set aside her bias or his bias.
Well, have we ever said an answer
That's not the
from
way-
the group or an answer from another juror will purge the
No,
bias
no,
of
and there's a
another
good
juror?
reason. There's a good reason for that, because a lot of people, mostly not lawyers, but a lot of people are not, eager to raise their hand. That they'll do it if they have to, but if they can just sit there, they'd rather do that. They don't want to single themselves out. So it's important in this situation.
This juror did. this juror raised her hand or his hand and said, I have that problem. Adult child can't do it. And just listen to the questions with juror number 123, who ultimately got excused because he said, basically, I haven't changed my mind, I still can't do it. So
She didn't say that.
Or
Or she didn't say why. It could, because the questioning also concerned whether a juror could be fair, whether there's voluminous evidence.
Right.
Or only one witness.
My point is that the juror knows, juror 383 knows that if they really have a problem with this, they can get out of it. They can just say, look, I can't do it. I can't follow the law, I just can't do it. Just like juror 123 did.
Yes, but still the juror could be in a situation where she really wants to serve, which is fine, but still really can't put aside
Well, see, now
that
you're getting to my
bias.
initial question to you, which is jurors lie. I mean, not intentionally.
Well, I don't know if they, but.
Well, I asked you, I said, have you ever had somebody, you ask them a direct question, can you be fair? And they say yes, and you know darn well that they can't. I mean, that's why we get peremptories. And you can tell by tone, you can tell by body language, you can tell by a number of things whether or not it's true.
Yeah.
So it's just simply one question, the argument here, I guess, is if that one question had been asked, as prejudiced as she may have been, she's in. And that's not the way we do it. And that's why, when the defense lawyer asked and when, the judge says, let's say they bring in lots and lots of witnesses, lots of evidence, lots of DNA, lots of pictures, and you're still not convinced, can you render a verdict of not guilty? And she said, yes. I know it's not a question.
Yeah, again, it doesn't it doesn't confront her with her bias. And this court has said that once a juror has expressed a bias, a defendant is entitled, at a minimum, not a maximum, but a minimum, is entitled to have that juror's express assurance on the record that the juror can put that bias aside. And this record doesn't.
Should the defense lawyer say, Judge, I want to ask another question, I want to ask, specifically this? I'm not looking, to pass blame here, but, apparently everybody seemed to think there was enough information here to make a determination. And the judge said, I think she's okay, and the defense lawyer said, then I'm going to knock her off. Peremptory.
Well, I mean, the defense lawyer has a certain amount of time to ask questions, and that time was exhausted. And the defense lawyer felt that she hadn't been, she had expressed a bias, and she hadn't disavowed that bias. So,
Thank you, Mr. Conley.
thank you.
Thank you.
Garcon, there's no expression that she can be fair. She didn't set aside her bias.
Well, the questioning immediately following the question with juror 123, and I know we're kind of getting, as you said, into the weeds, is he uses the term fair and impartial, meaning Judge Hall. He says, if the people are able to prove their case beyond a reasonable doubt, what would your fair and impartial verdict be? And she says guilty. And then he goes through that example of, now if they go through all this, he says, then what does your verdict have to be? He doesn't use the words fair and impartial verdict anymore. But again, I think what's happening is separating things out into snippets is what we're saying the court shouldn't do, that don't look at it in a vacuum, look at it in the totality.
Yes, but at some point, the juror's got to express, prospective juror's got to express in some way. Let's accept that you're correct about it doesn't have to be any magic words that the judge uses or magic words that the prospective juror uses, but at some point she's got to express that she can move, or the juror can move beyond the bias. What disqualifies that person? That's what disqualifies, not whether or not she can weigh the evidence or understands what reasonable doubt is or won't understand what reasonable doubt is or won't or will follow the instructions. Those are all other reasons not to keep this juror on or to keep this juror on. But the one that the juror has articulated is the one that juror's then got to say, I can get beyond this, I'm not going to rely on this bias.
Sorry.
With all the reading that's gone on from various members of the bench, I still don't see where that was expressed.
And my argument to you would be that, in fact, if you read it in the total, so that we don't pull out pieces and say, well, where's that language where he said.
Why shouldn't we, is what I'm saying. Why shouldn't we be looking for the expression that I can get past my bias, or my bias will not influence my vote? Why shouldn't we have that express statement? What is wrong with that? Why not have that clarity?
I will
A
say
person's
that
liberty is on the line.
I don't think there's anything wrong with that. I think that's what the law was at one time. One time it was, we can't trust jurors that say they have a bias. Then it was, well, we can, but they have to give this expurgatory oath. And then it came about, 270-20, we don't have to have an expurgatory oath. It's essentially just saying we do have to have an expurgatory oath. Say these words in this way, get your yes, and we're off to the races. But as we've heard,
She could say, the juror could say anyway, I'm not going to be biased. No, the bias won't get in my way. I can put it aside. Look, I just gave you 3 different ways I can deal with this. Not magic phrases or the exact same sentence or, right? There are different ways of expressing it, but again, when a person's liberty is at interest, what is wrong with having that express statement on the record?
I think that the juror expressed to the judge.
And by the way, when a juror expresses that, isn't that also confirming for the juror, they mean it, this is real, I have to put this bias behind me. It's not just part of several sentences and questions that I've just gone through that didn't mention bias, didn't get back to that specifically.
I guess the question comes down to, is there going to be a requirement for an expurgatory oath? And if you read the total record here, I would suggest to the court that the juror essentially says, I can be fair when they say I can give a fair verdict, and that if they don't prove the case, it's a not guilty. Thank you.
Thank you, sir.